Okay, let's continue powering through this document. Um, we were we left off. We were about to start reasonable defensive measures in the. So let's go through this now. Plaintiffs. When I say plaintiff, I'm referring to Lively. Defendants are obviously Wayfarer, Ainsworth Movie, Tag. So plaintiffs proposed instruction. It is not an adverse employment action for an employer to defend itself against allegations by, for example, denying that the alleged harassment occurred, but an employer may not attack the complainant's character or professional reputation or threaten, intimidate, or otherwise interfere with someone's right to pursue a claim for harassment or retaliation. Wayfarer's proposed instructions. So in case you haven't seen previous videos, the format is they either separately or there has been one joint one. They put forward their respective proposed instruction, and then they where it's plaintiff's position, defendant's position, this kind of arguing like why the other side's is shit, doesn't apply, is prejudicial, etc., and why theirs makes better sense. So that's how this is, right? So that was plaintiff's proposed instruction. This is defendant's proposed instruction. Parties accused of harassment and discrimination are permitted to defend themselves. Thus, even if you conclude that defendants engaged in certain activities in response to protected activities, you cannot find for the plaintiff if you determine that defendant's actions were reasonable defensive measures taken in response to her actions. So, plaintiff's position on this. Defendant's proposed instruction is confusing, argumentative, and ignores the very case upon which it relies, as well as the court's April 2nd order. The case law is clear that reasonable defensive measures do not include character or reputational attacks or threats, intimidation, or other interferences with the right to remediate harassment. Okay. If the jury is instructed on this defense, it is critical that it also be instructed on the limitations thereof to avoid a jury finding inconsistent with the law. I do actually agree with Lively on that last sentence, right? So if they are, I do think if the jury is instructed on they are given Wayfarer's proposed instruction, then they should also be instructed on limitations as well. So you've got to balance. The defendant's position. Plaintiff's proposed instruction is confusing and argumentative. Defendant's instruction is consistent with the court's summary judgment ruling. Dismiss claims by Ainsworth Movie against Miss Lively. Plaintiff's proposed instruction. After Miss Lively filed her CRD complaint and federal lawsuit alleging defendant's retaliatory conduct, the defendants filed a lawsuit against Miss Lively and Mr. Reynolds seeking $400 million in damages. Okay. The court dismissed the lawsuit. Sorry, I was just checking my blood sugar levels then. The court dismissed the lawsuit for failing to state a claim on which relief can be granted and ruled that defendant's lawsuit included legally frivolous and factually baseless claims. You are instructed that this lawsuit was, by definition, not a reasonable defensive measure under the law. And then the defendants proposed instruction, they don't have one, but they'll argue against Lively's. Plaintiff's position. Plaintiff maintains that this instruction is appropriate and consistent with the court's ruling and is necessary given plaintiff's allegation that defendant's dismissed lawsuit constitutes an adverse action against her, which remains part of the case. As this court has recognized, by suing an employee who files charges or engages in other protected activity, an employer can place its employees on notice that anyone who engages in such conduct is subjecting himself to the possibility of a burdensome lawsuit. And then we have defendant's position. Plaintiff's instruction is argumentative, prejudicial, and contrary to the law and facts. Defendants have filed motions in limine to exclude references to defendant's affirmative complaint and Rule 11 motions or orders. The instruction is also misleading. The instruction is simply meant to inflame and prejudice the jury. Yeah, I actually agree with that. I do actually agree with Wayfarer that. It's basically saying, well, they filed a lawsuit which was by the very definition of, the order was frivolous, baseless, therefore retaliatory in its own right, kind of thing. And when Lively doesn't even want her public statements following the motion for summary judgment, which dismissed most of her claims to be, she's requested a motion in limine to keep them excluded from any testimony or evidence of them being, put forward to the jury. Then I think it's a bit rich that she's kind of, wants to, do a lap of honor in the court with Wayfarer's dismissed claims. So, yeah, maybe set this one out Lively. Okay, let's continue. Where am I? Oh, yeah. So, substantial motivating reason. As to the third element, substantial motivating reason is a reason that actually contributed to the pattern of conduct towards Miss Lively. It must so this is it looks like it's a joint thing, and the causation, it looks like a joint it looks like a joint proposal. As to the third element, substantial motivating reason is a reason that actually contributed to the pattern of conduct towards Miss Lively. It must be more than a remote or trivial reason. It does not have to be the only reason motivating such conduct, which is what I said about, well, the other motivation could be, they were pissed off that she tried to steal the film, basically, and tried to, and it was risking harming the film. That's something that Sony executives also conceded to in their text messages. But, so it doesn't have to be the only reason, but it has to be the substantial reason. So if the jury look at all the evidence and go, well, actually, and let's assume, I don't believe this, but let's assume for a moment, Wayfarer did actually smear Lively and there is evidence of it. The jury then has to look at all the evidence and come to the conclusion that it was substantially because Lively complained about a hostile work environment or, because of the protected activity, i.e. she raised complaints about her, belief that she was being sexually harassed, right? If the jury looks at all the evidence and goes, actually, it looks more like the reason they were pissed off with her is because she tried to steal this film that they'd been working for years on, spent a lot of time and money on. If taking over the movie is actually what the jury deemed to be this substantial factor, then Lively cannot win. Even if there is some evidence to show that her belief that she was being sexually harassed and her, protected activity in raising complaints about it was a minor part of it. A minor is not enough. It's got to be substantial. Then we got causation. As to the fourth and fifth elements, Miss Lively must also establish that she was harmed and that Wayfarer Studios' conduct was a substantial factor in causing that harm. A substantial factor in causing harm is a factor that a reasonable person would consider to have contributed to the harm. It must be more than a remote or trivial factor. It does not have to be the only cause of the harm. Conduct is not a substantial factor in causing harm if the same harm would have occurred without the conduct. So, again, other factors are likely to consider here as causing Lively's harm is herself. The way she approached questions about domestic violence. The way she tried to make such a serious topic all flowery. The way she, opportunistically cross-promoted her own products and brands where she had no business doing that. The fact that she, linked her alcohol beverages with a movie about domestic violence, knowing that there is a causal link between alcohol, and domestic violence. There could be any number of reasons. Lively has got her burden is that she has got to prove that Wayfarer's conduct was the substantial factor. And I think she's going to struggle because even if it was a factor, to say in amongst all those other factors that it was the substantial factor is a stretch, in my opinion. Like, how can you dismiss the way, her flippant way of in interviews of when the subject matter of domestic violence arose, the way she handled that? How can you dismiss that? That's what pissed me off. I mean, people were pissed off with Lively even being cast as Lily Bloom. They felt she was too old and just not a good actress. So there was already a backlash there before, right as soon as she was announced to have taken on the role, before she ever set foot on any set, there was already a backlash. And Wayfarer are going to present evidence of all of this, and Lively's going to have to prove that all these other factors had no bearing, had very little bearing at best, and that the substantial factor that caused her to be harmed was Wayfarer's conduct. I don't see how she can do it. I just can't. Even if I was Team Lively, I couldn't see how she could do it. Right, okay. So, same decision, right? There's no proposed instruction from Lively. From Wayfarer, plaintiff claims that the defendants retaliated against her because of her complaints about or opposition to alleged sexual harassment. Wayfarer Studios and It Ends With Us movie claim that their conduct was not directed toward or in retaliation toward any protected activity, but was instead intended to protect their reputations and the film's reputation in the event of adverse media, which is lawful. If you find that retaliation was a substantial motivating reason for Wayfarer Studios and It Ends With Us movie's conduct, then you must consider Wayfarer Studios and It Ends With Us movie's stated reason for its conduct. If you find that defendants' concerns about protecting their reputations and the film's reputation was also a substantial motivating reason, then you must determine whether the defendant has proven that they would have engaged in the same conduct anyway at that time, even if they had not also been substantially motivated by retaliation. If you find that Wayfarer Studios and It Ends With Us movie would have engaged in the same conduct anyway at that time for other reasons, then plaintiff will not be entitled to damages. Exactly. Lively's position on this, because she didn't propose any instruction, but she has a position on it. Defendants are not entitled to this instruction because they failed to plead and therefore waived the mixed motive same decision affirmative defense. Okay. Under Alamo, a defendant must plead mixed motive same decision as an affirmative defense to preserve it. In Alamo, the court held that the defendant was not entitled to an instruction on the mixed motive defense as a potential limitation on remedies because it did not plead the defense in its answer to plaintiff's complaint, nor did it assert as an affirmative defense that it had lawful reasons for discharging her. This ruling was grounded in the California Supreme Court's decision in Harris, stating that if an employer wishes to assert the defense, it should plead that if it is found that its actions were motivated by both discriminatory and non-discriminatory reasons, the non-discriminatory reasons alone would have induced it to make the same decision. Neither Wayfarer nor It Ends With Us movie asserted a mixed motive or legitimate business reasons defense in their answers, and as such, they may not assert them now. If this instruction is included, which it should not be, it should be administered in connection with damages instructions because it goes to a limitation of remedies rather than liability. Despite advance notice of plaintiff's position with respect to this instruction and the Alamo case, defendants waited until after 6 p.m. Eastern. Oh, God. On the day of filing, she said this in every single one. They filed it late. On the day of filing, to provide any reason or related case law. Plaintiff reserves all rights to respond to the additional information and argument untimely provided by defendants. Okay. And then we've obviously got the position from Wayfarer. So they cite Alamo. Does not apply to pleading requirements as those are governed by Rule 8 of the Federal Rules of Civil Procedure, not California's Code of Civil Procedure. In the Second Circuit, failure to plead an affirmative defense does not necessarily lead to a waiver, and courts routinely consider unpled affirmative defense where there is no surprise or prejudice. Moreover, the Second Circuit does not treat the defense of same decision, often called mixed motive, as a true affirmative defense for the purposes of Rule 8. In addition, plaintiff can show no prejudice from the inclusion of the defense. She would not have conducted additional discovery or developed a different theory of liability. Yeah, that's fair. And it's not like this is a surprise, because they did, yeah, the actual defense itself, they may not have pled it, but Wayfarer's contention that, they hired a crisis PR to mitigate, reputational harm that Lively was causing is not a surprise. It's not a surprise at all. Okay, so now we have aiding and abetting instructions. Plaintiff's proposed instruction. If you find that Miss Lively was subject to retaliation, then you must determine whether tag. Right, so this is about tag now. The last one was Wayfarer and It Ends With Us movie. This is tags, jury instructions. If you find that Lively was subject to retaliation, then you must determine whether tag aided and abetted Wayfarer Studios' It Ends With Us movie in that retaliation. To find that these individuals aided and abetted retaliation, you must find that 1. Tag knew that Miss Lively engaged in protected activity, and 2. Tag substantially assisted or encouraged Wayfarer Studios' It Ends With Us movie's retaliation against Miss Lively. Okay. Defendant's proposed instruction. If you find that Wayfarer Studios or It Ends With Us movie committed retaliation that harmed Miss Lively, then you must determine whether Tag is also responsible for the harm. Tag is responsible as an aider and abettor if Miss Lively proves each and all of the following. 1. That Tag knew that retaliation was being committed by Wayfarer or It Ends With Us movie against Miss Lively. 2. That Tag gave substantial assistance or encouragement to Wayfarer or It Ends With Us movie. And 3, she needs all of these, don't forget, Tag's conduct was a substantial factor in causing harm to Miss Lively. Mere knowledge that retaliation was being committed and the failure to prevent it do not constitute aiding and abetting. So, plaintiff's position. Defendant's proposed language is confusing. No, it's not confusing. It makes better sense than yours. Is confusing and relies on CACI 3610. That CACI instruction, however, applies to traditional tort claims, not employment claims, and specifically not claims asserted under FEHA. I mean, how can you say that Tag? How can you have an employment? How can Lively have an employment claim over Tag? It would be tort. The instruction, as proposed by defendants, imposes burdens that do not exist under California Government Code 129401 and is therefore improper. And then Wayfarer, Tag's position, this will be, the CACI instruction should be used rather than a special instruction created by plaintiff. Retaliation is a tort, and plaintiff is seeking tort remedies. Yeah, it's what I've just said. Moreover, ALC, relied on by the plaintiff, specifically states that FIHA does not provide a definition of aiding and abetting, so it is appropriate to look to the common law. That is what defendants have done. I completely agree with that. So now we have the breach of contract instructions. And again, this one is one that I have been really pissed off about that it has remained, because it was Blakell Inc. that contracted with It Ends With Us movie. It was not Blake Lively as an individual, and you cannot interchange even if it's the sole shareholder of an entity, that person cannot, sue for a breach of contract in there as an individual for something that they signed in their, from their, as a signatory to their corporate entity. Okay, so we have breach of contract. So this annoys me because I don't believe that Blake Lively has standing to sue Ends With Us movie for this breach of contract for the contract rider. Blakell Inc. should be suing for that breach. Okay, A. Breach of contract introduction. Ms. Lively's claims that she and It Ends With Us movie entered into a protections agreement dated November 15th, 2023. That agreement provides any changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work, as a result of these requests is retaliatory and unacceptable and will be met with immediate action. I will refer to this provision as the anti-retaliation contract provision. Ms. Lively claims that It Ends With Us movie breached this provision by retaliating against her for complaining about or opposing the same. Ms. Lively also claims that It Ends With Us movie's breach caused her harm for what It Ends With Us movie, for which It Ends With Us movie should pay. It Ends With Us movie denies these claims. Okay, so Wayfarer's proposed instruction is: Ms. Lively claims that It Ends With Us movie LLC breached a contract known as the CRA by retaliating against her for raising concerns as described in the CRA. Ms. Lively also claims that It Ends With Us movie's breach caused Ms. Lively harm for which It Ends With Us movie should pay. It Ends With Us movie denies these claims. It Ends With Us movie also claims it entered into the contract under duress. So Lively's position on this. Plaintiff's proposed instruction includes the language of the specific provision that Ms. Lively alleged It Ends With Us movie breached. It is important that the jury understand the specific nature of Ms. Lively's claim to avoid confusion. Defendant's proposed instruction is vague as to both what provision was breached and how, and is likely to cause jury confusion. Plaintiff also submits that the protections agreement should be uniformly referred to as a defined term throughout. Further, defendant's reference to economic duress is inappropriate, misleading, and confusing. There is no evidence of duress, a wrongful threat, or a wrongful act here, to the extent that defendants alleged in their affirmative complaint that complaint has been dismissed with prejudice. In addition, the court has already rejected defendants' alleged economic duress theory in granting plaintiff's motion to dismiss. Defendants cannot revive this defective theory as a defense. Okay, so now we got defendant's position. Contracts must be read as a whole. I think Wayfarer, It Ends With Us maybe tag whoever, right? Whoever is looking at this, I think it's going to be It Ends With Us movie. Either way, I think the attorneys, right, are looking at this and I think they know that there is no contract between for Blake Lively. She is not a party to this contract that she's seeking damages for breach of. I think they know it. And they're about to show us this. Contracts must be read as a whole, right? There's your first clue. and it is inappropriate to limit the jury's analysis of the contract in a jury instruction introducing the claim. Defendant's instruction below relates to the provision at issue. Defendant's instruction here more closely follows the CACI. Defendant is also entitled to assert its direct defence. So that's your first clue. The contracts must be read as a whole. Lively's trying to introduce one paragraph, and Ainsworth's movie are like, no, let's look at it all, right? And now they're going to go through the elements. Breach of contract, essential factual elements. To recover damages for the breach of contract, Miss Lively must prove all of the following. And at the top, the first thing they say, that Miss Lively and Ainsworth's movie entered into a contract. So Lively's got to prove that she was the one that entered into the contract with Ainsworth's movie. And she can't do it. Because they're going to be saying, okay, but why was it signed on behalf of Blakell Inc.? And also, in the contract itself, in the actual cause of action, it also Lively also confirms that it was Blakell Inc. that honoured all of its responsibilities and basically kept its end of the bargain. So again, why is Lively claiming damages? I know I sound like a broken record on this point, but it's for me like contract law was it's a big thing for me. My qualifications are largely in corporation law, mergers and acquisitions, banking, employment law, international law. So contract and the terms are really, really important for me. They're a big thing for me in my employment. And details like this matter. And I don't think Wayfarer have missed it. I think they know. I think Lively's team might have missed it, though. So, to recover damages for the breach of contract, Miss Lively must prove all of the following. So, these are the essential elements. Then the first one is Miss Lively and Ainsworth's movie entered into a contract. She can't do it. I think she's going to stop there. She can't go any further. 2, Ainsworth's movie did something that the contract prohibited from doing. 3, that Miss Lively was harmed. And she wasn't. You got to think at the time, orient yourself to the point of time, right? That the 17-point demand was put forward, yeah? So Lively, sent it to Wayfarer, Ainsworth's movie, whoever, Jamie Heath, in November, right? November 2023. Okay, it wasn't signed until January 2024. But it was signed, and they resumed phase 2. Everything went fine. She had control of the marketing. She got her own cut. She edited it all. She brought on all her famous friends and called in favors. She then applied for the PGA, which she got. So what harm? This is not the retaliation. The retaliation did come, laid further on down the line in August. Not that it did come. Sorry, the alleged retaliation came further down the line in August. But again, she's got to prove the harm. And then the fourth element is that Ainsworth's movie's breach of contract was a substantial factor in causing Miss Lively's harm. Again, I'm not sure she can do that because there are just so many factors. And I think proximity is a problem here as well. Even and I'm not entirely sure I agree with Lyman that the all hands meeting in January 2024 was protected activity, right? She lured them there under false pretenses, firstly, And where was the all hands? I mean, she said there was no HR. Why didn't she invite HR to that meeting? Why did she even have it in her house, in a apartment? Why didn't she go Wayfarer and the end of this movie? They had premises and offices in New Jersey. Why didn't she go to there? So and having this meeting in your home, where your husband is, where your kids maybe, where your staff are walking around, and I mean, the text message to Justin Baldoni was, "You can come alone if you want." When other people were informed, they were very much under the impression, and Giannetti was under the impression, as was Todd Black, that it was to discuss, script changes and getting back ready for production to restart filming. No one had any clue, right up to the moment they got there, that it was going to be, about what had gone on months before, allegedly. Because the 17-point list, a lot of that had already been executed anyway, aside from the fact there were stuff there on that list already, such as an intimacy coordinator, although they hired a second one. Nudity riders were already in place, although Lively had refused to sign hers. Todd Black was already in place. The Sony representative, I think they agreed it might not always be Ange Giannetti, but that was who Lively nominated. That all of that stuff was in place. So the meeting was kind of, it was almost like an ambush, really. It was like, yeah, come over, let's get, things moving to start filming again. And they basically all walked into a trap. A 6-hour long torture chamber. So, and I'm hoping that Wayfarer will actually present evidence to prove that there was no pre-planning that this was going to be a protected activity. And in reality, okay, Lively read a list from her phone. But who was the one that was screaming? That'd be Ryan Reynolds. Was he engaging in protected activity? Don't think so. And there's obviously dispute over what she was reading off the phone, because it was a 30-point list. That's what she submitted with her CRD. Well, Ryan Reynolds said it was like a 27-point list. He referred to it as a 27-point list to Warren Zavala. So where do the other points come from? And then there's a whole, confusion, shall we call it? Yeah, it would be nice. We'll call it confusion over the metadata on that list. It doesn't make sense or can't be found. So I have issues with, I mean, Lyman has suggested the jury may find that it is protected activity, that meeting. I argue that I don't think it should be. I really don't. Okay. Let's continue. Breach of contract provision at issue. So plaintiffs proposed instruction they don't have. Defendants proposed instruction. Plaintiff claims that Ainsworth's movie breached the following contractual provision. I'm not going to read that again because we've already read it. To prove that Ainsworth's movie breached this provision, plaintiff must prove that the requests included in the CRA were the but-for cause of any alleged retaliatory conduct. This is a higher standard of causation than what is required for the FIHA claims. So what that means is Lively's got to prove that that basically these requests that were in the contract rider, the 17-point list, but for them being breached, there would not have been retaliation. It means plaintiff must show that the allegedly retaliatory conduct could not have occurred in the absence of her request. Okay, so she can't just say, well, because you did retaliate against me, you broke this contract. She's got to prove that the retaliatory conduct would not have happened but for, had it not been for the fact that Ainsworth's movie breached this contract, I think she's going to find a really difficult. She's going to find that incredibly difficult to prove that. Plaintiff's position. Okay. Lively's position. Plaintiff has accounted for the first paragraph of this instruction in her proposed introduction to contract instruction. In the event that the court does not accept that proposal, plaintiff is amenable to including a separate instruction as to the exact provision at issue. Plaintiff, however, is not amenable to including the second paragraph of this instruction, which is confusing and misleading. The protections agreement specifically defines what will constitute retaliation. Any changes in attitude, sarcasm, marginalization, or other negative behavior. Literally, if Justin Bolt only walked into work one day, with having had a bad day, and he just didn't have a great big smile across his face, then even that would have counted as retaliation in this ridiculously broad and very subjective test here. I mean, who's judging the changes in attitude and sarcasm? Is it just Lively? Or is it if someone else, if Jenny Slate said, oh, he's a bit off today, he's probably retaliating against you. This is how stupid this is. And in the UK, this would be considered an unreasonable and unfair contract term. It's completely unreasonable. And as a result, it wouldn't stand either. For this reason and others, plaintiff is not required to prove that the protections were a but-for cause of retaliatory conduct. Defendants' proposed additions to that effect manufacture a high burden upon plaintiff that simply does not exist. Further, the case upon which defendants rely, Burrage, does not include any breach of contract allegations and instead is a criminal case that concerns statutory interpretation, specifically of the Controlled Substance Act, and when a defendant may be liable thereunder when death or serious bodily injury results from one of the distributed substance. It is therefore wholly inapposite. Defendant's position. The proposed instruction is a correct statement of law and it's critical to instruct the jury on the appropriate standard for causation. Yeah, because this is a contract claim. So causation is important. The defendant's proposed instruction is consistent with the Supreme Court's explanation in Burrage that the ordinary meaning of results is actual causality. In the usual course, this requires proof that the harm would not have occurred in the absence of, that is, but for, the defendant's conduct. Okay, so now we get to affirmative defense, and we're going to start with economic duress. Plaintiffs have no position, not for the first time in this case. Defendant's position. Ainsworth's movie claims that there was no contract because its consent was given under duress. To succeed, Ainsworth's movie must prove all of the following. 1. That Miss Lively used a wrongful act or wrongful threat to pressure Ainsworth's movie into consenting to the contract. 2. That a reasonable person in Ainsworth's movie's position would have believed that there was no reasonable alternative except to consent to the contract. And 3. That Ainsworth's movie would not have consented to the contract without the wrongful act or the wrongful threat. An act or threat is wrongful if a bad faith breach of contract is threatened or the resulting exchange is not on fair terms and what is threatened is otherwise a use of power for illegitimate ends. If you decide that Ainsworth's movie has proved all of the above, then no contract was created. Lively's position. This instruction is unnecessary and inapplicable. There is no evidence of duress, a wrongful threat, or wrongful act. Wayfarer have the right to rely on that defense that they were coerced. They have the right to do that. The directions for use make clear that this instruction is completely inapplicable here. To the extent that defendants allege so in their affirmative complaint, that complaint has been dismissed with prejudice. Well, they actually also raised it in when they were, answered Lively's complaint too. In addition, the court has already rejected defendants' alleged economic duress theory in granting plaintiffs' motion to dismiss. Defendants cannot revive this defective theory in a defense. And then defendant's position, evidence of duress will be presented. The court's ruling on an affirmative claim does not have bearing on the defense presented by defendant. Damages. Introduction to damages. My next instructions are on the law of damages. If you decide that Miss Lively has proved any of her claims against Wayfarer, Ainsworth's Movie, or Tag, you must also decide how much money, if any, will reasonably compensate Miss Lively for the harm, if any, caused by the breach. The fact that I'm going to instruct you on damages does not reflect any view as to whether you should award Miss Lively damages. Instructions as to the measure of damages are simply given for your guidance in the event you return a verdict in favour of a party. If you decide that Miss Lively has not sustained her burden of proof as to any of her claims, you need not consider damages. The purpose of the law of damages is to award, as far as possible, just and fair compensation for the loss, if any, that the plaintiff has suffered as a result of the actions of any defendant you are considering. Any damages that you award must be fair and reasonable, and neither inadequate nor excessive. In awarding damages, if you decide to award them, you must be guided by dispassionate common sense. Okay. Computing damages may be difficult, but you must not let that difficulty lead you to engage in arbitrary guesswork or speculation. You may not award damages based on speculation. On the other hand, the law does not require injured parties to prove the amount of their losses with mathematical precision, but only with as much definiteness and accuracy as the circumstances permit. In all instances, you are to use sound direction in fixing an award of damages, drawing reasonable inferences where you deem appropriate from the facts and circumstances in evidence. The verdict form I will give you will assist in recording the determinations, if any, that you make as to damages. Okay, so there's a joint position on this. Defendants contend the first paragraph should read, "My next instructions are on the law of damages. If you decide that Miss Lively has proved any of her claims against Wayfarer, Ainsworth's Movie, or Tag, you must also decide how much money, if any, will reasonably compensate Miss Lively for the harm, if any, caused by defendants." Plaintiff disagrees and maintains the instruction should read, "caused by the breach." Okay. Okay. Non-economic and economic damages. The damages claimed by Miss Lively for the harm caused by Wayfarer Studios, Ainsworth's Movie, and Tag fall into two categories called economic damages and non-economic damages. You will be asked on the verdict form to state two categories of damages separately. Damages on multiple legal theories. So this is Lively's proposed instruction. Miss Lively seeks damages from Wayfarer Studios. It ends with this movie and Tag under more than one legal theory. However, each item of damages may be awarded only once, regardless of the number of legal theories alleged. You will be asked to decide whether Wayfarer Studios, it ends with this movie, and or Tag are liable to Miss Lively under the following legal theories. 1. Retaliation. 2. Aiding and abetting retaliation. 3. Breach of contract. The following items of damages are recoverable only once under all of the above legal theories. 1. Lost past earnings. 2. Lost future earnings. 3. Lost profits. 4. Reputational harm. 5. Emotional distress. So, defendant's proposed instruction. Miss Lively seeks damages from Wayfarer Studios at Ainsworth's Movie and Tag under more than one legal theory. However, each item of damages may be awarded only once, regardless of the number of legal theories alleged. You will be asked to decide whether Wayfarer Studios at Ainsworth's Movie and or Tag are liable to Miss Lively under the following legal theories. 1. Retaliation. 2. Aiding and abetting retaliation. 3. Breach of contract. The following items of damages are recoverable only once under all of the above legal theories. 1. Lost past earnings. 2. Lost future earnings. 3. Lost profits. So we've lost a couple there from reputational harm and emotional distress. Wayfarer is saying, no, we're not adding that. The following additional items of damages are recoverable only once for retaliation and aiding and abetting retaliation. 1. Garden variety, emotional distress. Lively's position. On the parties' conferral, defendants refuse to provide the basis for their position that Miss Lively has waived the right to claim reputational harm, notwithstanding the disclosure of reputational harm in Miss Lively's initial disclosures and expert reports. Yeah, but she only included it after the discovery window had closed, so Wayfarer weren't able to do discovery on this. Notwithstanding the disclosure of reputational harm in Miss Lively's initial disclosures and expert reports, Miss Lively never maintained that she has sustained reputational harm, only in connection with her defamation claim. Yeah, that's the other thing. Defamation claim got yeeted. Instead, Miss Lively has long disclosed she seeks reputational damages for the harm incurred from retaliatory public statements and those attributable to the retaliatory campaign. Again, this bothers me, right? Because what statements, right? Friedman statements are not part of this anymore. So what statements did Wayfarer make? Which ones? Plaintiff asserts that she's entitled to emotional distress damages under the Protections Agreement as an express object of which was to ensure plaintiff's mental and emotional well-being, which the court already recognised is a basis to recover emotional distress damages under contract. You agreed to garden variety. In addition, plaintiffs first provided this information after 6 p.m. Eastern on the day of filing, blah, blah, blah. In addition, that the court is inclined to accept defendant's instruction, plaintiff requests an opportunity for further briefing, or opportunity, as she's written. Defendant's position on this. Plaintiff has waived any right to claim reputational harm as described in defendant's motion in limine. In addition, emotional distress is not available for plaintiff's breach of contract claim. Yeah, I didn't see anything in there about emotional distress. The jury must also be instructed regarding the type of emotional distress plaintiff can recover in this garden variety, as she has waived her right to seek other emotional distress damages. Yeah, exactly. She didn't want discovery done on it. She withdrew her intentional and negligent infliction of emotional distress, and she agreed to just garden variety. Now she's trying to say, well, under the CRA, I'm entitled to emotional damages through that too. It doesn't even say emotional distress. It says nothing about it. Multiple defendants and claims. In this case, Miss Lively seeks damages from more than one defendant. You must determine the liability of each defendant to Miss Lively separately. If you determine that more than one defendant is liable to Miss Lively for damages, you will be asked to find Miss Lively's total damages. In deciding on the amount of damages, Consider only Miss Lively's claimed losses. Do not attempt to divide the damages among the dependents. The allocation of responsibility for payment of damages among multiple defendants is to be done by the court after you reach your verdict. So that was the. I don't see any. Lively's rejecting defendant's proposed addition, but I don't see it. Plaintiff rejects defendant's proposed addition with respect to comparative fault on the basis that it does not apply to plaintiff's claims. Wayfarer's position, the second sentence should state, if you determine that more than one defendant is liable to Miss Lively for damages, you will be asked to find Miss Lively's total damages and the comparative fault of Miss Lively, each defendant, and other non-parties. This language is included in the CACI instruction. Miss Lively does not seek solely contract damages. Right, FEHA retaliation damages. So there's a joint instruction. I'm going to read this and then I'm going to stop the video and do one. I think it's just one more part and then that'll be it. Okay, FEHA retaliation damages. Joint instruction. I will begin by instructing as to Miss Lively's claim damages for retaliation. If you decide that Wayfarer Studios or Ainsworth's movie are liable for retaliation, you must also decide how much money will reasonably compensate Miss Lively for the harm caused as a result. So, Lively's proposed addition. In a retaliation action under FEHA, all damages necessary to make the victim whole are authorized, including past and future lost earnings, past and future lost profits, past and future medical expenses. Why have they got medical expenses? She refused to allow access to her medical records. Other future economic loss, past and future non-economic loss, including mental suffering, reputational harm, and punitive damages. Mental suffering. Plaintiff's position. Plaintiff maintains that this proposed addition is appropriate and necessary to instruct the jury as to the scope of damages permissible under FEHA. Defendant's position, the second paragraph above, is unnecessary and argumentative. The types of damages sought are described below. Okay. Retaliation damages. I'm going to continue this though in I don't know what. No, I'll do this one. Retaliation damages, economic. Plaintiff's proposed instruction. The following are specific items of economic damages claimed by Miss Lively. Past and future lost earnings, including lost acting, endorsement, and speaking opportunities, and lost profits in the form of earnings associated with her brands. To recover damages for past lost earnings, Miss Lively must prove the amount of income, earnings, salary, wages, and/or profits that she has lost to date. To recover damages for future lost earnings, Miss Lively must prove the amount of income, earnings, salary, wages, and/or profits she will be reasonably certain to lose in the future as a result of the retaliation. Defendant's proposed instruction. The following are the specific items of economic damages claimed by Miss Lively. 1. Lost profits. To recover damages for lost profits, Miss Lively must prove it is reasonably certain she would have earned profits but for defendant's conduct. To decide the amount of damages for lost profits, you must determine the gross amount Miss Lively would have received but for defendant's conduct, and then subtract that from the amount the expenses Miss Lively would have had if defendant's conduct had not occurred. The amount of lost profits need not be calculated with mathematical precision, but there must be a reasonable basis for computing the loss. 2. Past and future lost earnings. To recover damages for past lost earnings, Miss Lively must prove the amount of income or earnings that she has lost to date. To recover damages for future lost earnings, Miss Lively must prove the amount of income or earnings she will be reasonably certain to lose in the future as a result of the injury. Plaintiff's position. The plaintiff disagrees with defendant's characterization of the damages that she seeks. Loss to plaintiff's brands constitute lost earnings to which she is entitled. How has there been a... I really can't wait to hear how she's going to spin losing money on her brands. She managed to get free marketing done through them as well. Defendant's position. Miss Lively does not claim lost salary or wages. Moreover, Miss Lively does not claim lost profits in the form of earnings associated with her brands. She claims the lost profits of businesses in which a separate company holds an interest. Defendants have moved in limine to preclude this evidence based on a lack of standing, although the reference to lost profits remains in the instruction for now. Okay, so yeah, I'm going to stop here, move on to part 3, and then we should get this document wrapped up, and then I'm going to move on to the Daubert motions, which should be really interesting.